In this video, we would like to discuss about revocation of wills and as it was expressed by Tabji in his work of Islamic law. According to Tabji, just as in other systems of law, so under Muslim law, a tester may revoke his will or any part of it at any time, either expressly or by implication. Similarly, a tester is also free to make any addition to his will, but if the addition to the subject of the bequest is such that the subject of the bequest cannot be delivered with the addition, then the bequest stands revoked, and revocation of will is divided into express revocation and implied revocation. And regarding express revocation, Professor Baillie, in his Digest of Islamic Law, Volume 1, expressed that if a tester makes a bequest of some property to a person and by subsequent will he bequeaths the same property to another person, the first bequest is revoked, but bequest of the same property to one person in earlier portion of the will and to another person in the latter portion of the will does not revoke the earlier bequest, but both the legatees share the property equally. A will may be expressly revoked by tearing it off or by burning it. It seems that mere denial of a will not operate as its revocation. And regarding implied revocation, also Baillie in his volume 1 expressed that any act inconsistent with the bequest will go to revoke the will. Thus, an act which results in the extinction of the subject matter of the bequest or extinction of the proprietary rights of the tester will impliedly revoke the will. For instance, bequest of a plot of land is revoked when the tester builds a house on it, or bequest of a house is revoked when the tester sells or makes a gift of it to another. And the most important concept under wasiyat or will is Marz-Ul-Maut or death illness will. And regarding that, we found detailed explanations given by Professor Baillie in his volume 1 and in volume 2 regarding Digest of Islamic Law, also Amir Ali in his volume 1. So, the very explanation of Professor Baillie regarding death, illness, will or basiyat is that the deathbed gifts are recognized in many systems of law. Though to what extent, in what circumstances such gifts can be made, The laws differ. Marz-Ul-Maut or gift of Muslim law derived their rules from two branches of Muslim law, the law of gifts and the law of wills. The law relating to the Marz-Ul-Maut is a combination of rules derived from both the branches. The different schools of Muslim law take divergent views on the Marz-Ul-Maut gifts. The Malikis take the view that Marz-Ul-Maut gifts are void. The Hanafis and the Shias hold that such gifts, to the extent of one third, is valid. So, a gift to be valid as Marz-Ul-Maut gift must be made during Marz-Ul-Maut or death illness. The most valid definition of Marz-Ul-Maut as it was given by Baillie is that a malady which is highly probable will issue fatally, where the malady of long duration, such a consumption, and there is no apprehension of death, the malady cannot be called Marz-Ul-Maut. The Muslim lawgivers hold the view that if a disease continues for a period of more than 1 year, then it cannot be called Marz-Ul-Maut. However, even then the disease may become Marz-Ul-Maut if it takes a stage where the apprehension of death is genuine or death is highly probable. When a person is in imminent fear of death, whether from disease or any other cause, so that in case of an illness, the man is so broken by it as to be incapable from conducting his ordinary avocation outside his house. For example, a jurist from going to the mass, a tradesman to his shop, a woman from attending to her indoor occupation. It is all Marz-Ul-Maut. Another test is that those laid down by Amir Ali, when the malady has become so severe as to make it permissible for the sufferer to offer his prayer without standing up, it must be regarded as illness of death. The Shia authorities are, to some effect, holds that every malady which is accompanied by a genuine apprehension of death is Marz-Ul-Maut. It is submitted that all those elements, whether dangerous or not, which results in death, should be regarded as Marz-Ul-Maut maladies. So, it is established that in order to constitute a Marz-Ul-Maut gift, the following conditions must be fulfilled. The first condition is that the malady or illness must result in death. The second, the malady or illness must cause a reasonable or genuine apprehension of death. in the mind of the sufferer. And the third condition, there should be some external indicia of a serious illness or malady. And the fourth condition is that delivery position must be given to the donee. So, in fact, the requirement is that there must be a subjective apprehension in mind of the donor that the death was imminent. It is a unique feature of Marz-Ul-Maut gift that it must fulfill all the requirements of a valid hiba, including delivery of position, and at the same time it is subject to all restriction of a will. It is therefore necessary to understand that a gift by a mariz or a sufferer is a contract and not a wasiyat, and the right of disposition is restricted to a third on account of right of heirs. Under the Ithana Ashari law, it can be made to an heir also, but among the Ismailia Shias, such a gift cannot be made to an heir without the consent of other heirs, as it was held in the leading case Abdul Hafiz versus Sahibi in 1975 by the Bombay High Court, and as regarding acknowledgement of debts. Under Muslim law, a person may acknowledge his liability or debt whether in health or ailing. The Muslim authorities take the view that a declaration or admission of liability by a Muslim is binding not only on the person who makes the declaration or admission but also on his heirs. In the same way, when the only proof of a debt or liability of the deceased in deathbed, acknowledgement of it, then the Muslim lawgivers rank it in respect of priority, midway between other debts and legacies. This means that other debts have priority over the deathbed acknowledgement. Such debts have priority over legacies. Even a divorce pronounced by a person who is suffering from a mortal malady cannot deprive the wife of her right of inheritance, as it was expressed by Faji in his Mohammedan law. So, regarding acknowledgement of debt, as it was expressed by Hanafis law, Ithana Ashari law, so also in Fatwai Almgiri, that all is important regarding the very wasiyat or will made in death in less of a Muslim, which is otherwise called Marz-Ul-Maut. So, before making any wasiyat in the death illness situation, a Muslim has to acknowledge all his debts, and it is on the liability of on the heirs to repay those debts by the Muslim who made such wasiyat under death illness, which is called Marz-Ul-Maut, and which is an important concept in Islamic law.